2000 as exemplary damages to the respondent. I therefore seek leave to introduce a persuasive precedent, a foreign precedent.
Sorry, before you go, in what capacity is Times 3 television so?
May you please raise the question?
Times 370 television, in what capacity is it?
I couldn't get the last part.
In what capacity? What is your locus standi?
We are the appellant.
The appearance. What is Times 370?
It's a press company.
It's a company.
Yes.
So a company is written as Times 370 television.
Yes.
That's all. And somehow you can think this is a person.
Yes.
You know about legal personality. When a person appears as a natural person, a person appears as a company. What do you add as the title of the company? According to the company's act, what do you add to it?
Yeah.
Limited, isn't it? Let's assume it's a company limited by shares. So it's Times 370 television limited. And that's the case.
Yes. Most obliged, my lordship. I would therefore seek for leave to introduce a persuasive precedent. Yes, so in the case of Brooks versus Bernard, it outlines the things that can be used, or requirements that can be used in order to award exemplary damages. And it says as follows: it can either be an oppressive, arbitrary, or unconstitutional action by the servant of government, or where the defendant is calculated to make a profit from the exceeds of compensation, and exemplary damages are explicitly authorized by statute. Now, in this case, in the case in Casio, the exemplary damages, the company in question, Times 370 Limited, it was not a government body, one, and they did not make any excessive profit from it. Therefore, they shouldn't be the ones to bear the burden of exemplary damages.
So they can't pay exemplary damages because they do not behave in an excessive way. Or they do not what?
They were not a government body.
Can I draw your mind to track it? So listen to this. Exemplary damages are no longer recoverable in defamation except where there has been an abuse of power, oppressive, arbitrary, or unconstitutional by servants of government. One of the assertions, right? Or where the defendant's conduct has been deliberately calculated to make him a profit, right? To exceed the compensation payable to the plaintiff. For example, by a newspaper deliberately publishing a defamatory statement with a view to increasing its circulation, which you have refused. This latter condition will not be fulfilled simply because it is published in a newspaper which itself is published for profit, but it will be fulfilled whether the newspaper deliberately publishes a statement knowing it to be false, reckless, or careless, whether it is true or false, and on the calculated basis that the compensatory damages would be less than the profit. So if I'm to construe it, not only does a statement have to be calculated to earn the profit, but it should also be made in a reckless, not caring whether it is true. When Madam Mercy had been consulted, did she agree that it actually happened? She didn't agree, right? And she said, you go and consult. Did he get the answer from the person you consulted?
No.
He did not. He went ahead to ask somebody who was only saying words that are piercing, inadmissible sentences, isn't it? Don't you think that would be reckless from a journalist to get information that is half-baked and posted in the newspaper? Isn't that defamatory? That's reckless.
Most obliged, my lordship. The reporter in question tried his level best to source out credible information. Therefore, that's why after it's proved, after he did not manage to get evidence from the provincial administration, administration. That's how he resorted to his friend who was in the same office.
His friend.
Yes.
That friend. Was that friend to Miss to Miss Chandler? What's her name? Nancy Patel. Was that a friend?
No.
That's a person who probably considered a commando or silencer, isn't it? Do you find that reliable?
It is reliable, looking at the fact that the reporter came there in search of the truth, and therefore he warned the accountant in question to say the truth and nothing but the truth.
So if you are a journalist and you inquire information firsthand, you don't get it. You get it, and on further inquiry you don't get it. You get information from second. Which information would you choose to decipher between the two? First-hand information or second-hand information from someone that is hearsay? What would you choose for you to be a journalist?
Second-hand information which has evidence to it.
You ignore the person who made the statement and you go for someone who made the statement about the person who made the statement. That's more credible to you.
Yes.
Okay. Proceed.
Most obliged, my lecture. It was stated in Winfield versus Jolowitz, in Winfield and Jolowitz in the book, page 23, 017, to say exemplary damages are used as punitive damages to deter others from doing it, to show that a tort does not pay. I'll emphasize on the point where the learned author said, so that the tort does not pay. In this case, times 370, their tort did not pay in question. The said defamation that took place, they never accrued any profits from the said publication.
That's what you found out.
From the facts, there was no information to state that they had benefited from the publication.
Neither are there facts to say that you don't benefit, right? Yes.
But
So you
facts,
are alleging that they did not. You're assuming that's factual. How are you going to do that? That's what we thought.
yes. And the second ground of appeal, which is,
Before you go to second ground, there is a consideration of profit to be gained, right? You agree this is a public figure in a public office of high esteem.
yes.
So if I make a report about, say, the district commissioner engaged in this on a basis, reasonable basis, do you think that paper would sell? Because people would be interested to know what did the DC do? Do you think that would entice curiosity?
No, it wouldn't.
It wouldn't. You don't care what the DC does. Let's say the VC of CPU, the VC has entered into an argument. Wouldn't you be interested to know exactly what did the VC do? You as a CPU student. Would you or would you not?
No, I wouldn't.
You would not. It doesn't bother you what the VC does.
Yes, my lord.
Proceed.
So the second round of appeal, the court erred in law and fact when they stated that the statement was defamatory. In the actual sense, the words that were used to say from law enforcer to lawbreaker, was that defamatory in the sense that it could limit or reduce the reputation of the said party? No, it wasn't. Because in as much as she was transferred in the same capacity, and therefore she did not suffer any effects from the defamation. And the defamation did
So you agree that it was defamation, but she just didn't suffer any effects from it. You just say.
No, I'm not agreeing.
You disagree with yourself. We agree that she did not suffer any effects from the defamation. From the defamation, she did not suffer any effect because nothing changed. Yes? Continue.
I would like to seek permission to correct myself on that. Yes. So this statement did information was not defamatory. Because even in the natural words, when we interpret the natural words as they are in their natural balance, it does not amount to anything that can reduce anyone's reputation in a society.
You're the one interpreting the statement. Whose name are you using?
Yes, my God.
I brought my mind to an innuendo. It is based on the circumstances. That means somebody must have prior knowledge of the circumstance that will make you say this, right? Why do you think she was called commando, according to facts?
Because of her behavior in the workplace.
Because of her behavior. Are there people who came to her asking why she was called commando? In the facts, are they there? There are no people who came to ask why do people call you this?
No.
Are you sure? As far as I'm concerned, people came to ask, why do they call you this? And she said it's because nobody but males have held this position for 20 years. They just are acting out of ill motive. Do you agree with that? It's yes or no. Do you agree with that?
With her statement.
Do you agree with her statement? The
The
statement?
facts.
Yes.
Yes, my
That
Lord.
people came to inquire.
Yes,
So that means a reasonable class of society would know if that was published in the newspaper and they say, oh yes, he's referred to as commando. Most likely, would that tend to lower estimation in the minds of right-thinking members of society? Or they would just say, it didn't. So how do you prove that?
because in as much as she was transferred in the same position, meaning her employers obviously had good faith in her that she's still a best candidate for that job.
Would she have been transferred if that didn't happen?
If the publication did not happen?
Yes. So you agree that the transfer only happened because of the issues that were going on? Yes. You agree with that? That means you found the statement offensive, and because of that, it had affected just how things were run there. It wasn't making sense anymore, and she had to move. Yes.
Most obliged, my lordship. However, in the facts, it does not.
You agree? Most obliged means okay.
No, I'm not.
What's your answer?
From the facts, the transfer that was made to her, was not based on the defamation.
You said that.
On the
You said it was
alleged
based on what?
defamation.
You're changing your mind. Okay. Yes.
Yes.
Thanks, your prayer.
Our prayer is that the Court of Appeal should grant this appeal to the appellants because the exemplary damages were too much and they shouldn't have been awarded in the first place. Most obliged, my lady.
Most obliged, my lady and my lord. I would love to draw you to ground 4.
Who's doing ground?
Agree? So much obliged. So what happened was my fellow counsel was moved to the other team due to lack of participants.
Your fellow counsel is this side.
Yes.
You did the brief all together.
Yes.
How many grounds are there?
Yeah, for
There are 4 grounds. So you do ground the other ground and she comes back and you come back. That's fine? Because I assume you know all the facts. Yes?
sure.
Proceed.
Ground 4. My lord and my lady, the appellant
So you do 3 and 4.
3 and 4.
3 and 4, yeah.
True. With your permission, is it okay if I can start with 4?
Okay.
Sure.
Wherever I want to start.
So I'll start from ground 4. The Appealant Times 370 television has several arguments against the damages that were awarded, focusing on their perceived unfairness and implications for the media freedom. My lady and my lord, the appellant, Ms. Patel, did not provide clear evidence of specific damages resulting from the broadcast. They could suggest that she should demonstrate tangible losses, like a decrease in salary or a missed job opportunity. My lord and my lady, nothing of the sort was done. Instead, she was kept on the same position, no harm was done.
So what are exemplary damages?
Exemplary damages. Much obliged, my lord, my lady. So exemplary damages, or known as punitive damages, these are damages that are put in place to set in an example of to the party that has injured the other party.
So, you find it right that the media use was to be set an example of displaying or disseminating unbaked information? Would you find it right if a journalist makes a report on unsatisfied facts to make an example? If you are a journalist, learn to research and work with facts. It's your calling. Would you find exemplary damages as okay in that instance?
Much obliged, my lady. Well, I don't find the examples, pardon me. Much obliged, my lord. I don't find the exemplary damages necessary, because we already have a precedent in the case of Charity Katanga versus Movie TV. Therefore, I see no reason why the exemplary damages could be awarded in this particular case, because it was just a mere freedom of expression enshrined in Article 20 of the Constitution. Charity Katanga, my lady. Much obliged. The case of Charity Katanga versus Movie TV began from the High Court. So,
I asked what was the principle?
Much obliged, my lady. So the principle in that particular case was it had established all the elements of defamation.
Which are?
Number one is that the message must be defamatory. Secondly, the words or the defamation itself must refer to the plaintiff. And thirdly, the words must be published.
And you're saying these words do not refer to the plaintiff?
Yes, my lady.
Have you heard of what is called an innuendo?
Much obliged, my lady, an innuendo. So, with your permission, I would love to go on and interpret with your permission, of course, what an innuendo is. So, an innuendo is simply, due to lack of a better term, I would love to go with the statements to say, an innuendo is simply an interpretation for you to find the subject that is being talked about. For instance, in this particular case, we have many people called by the name of commander, with reference to we have another commander in Lusaka.
And your client only chose to release that statement after that occasion?
Much obliged, my lady. My client, the media, Times 370, did not refer to the commander that was being talked about in this particular case.
The counsel just said it was. She said yes, commander does refer because she was called that because of her behavior. She agreed to that. You are saying she was misguided, was she?
My lord, she was not misguided.
So then it's you who is misguided.
I would love to go with the facts, but as it goes to say, wise art thou the judges? Council 6.
You're asking us why we're judges?
No, wise art thou the judges? No one is as wise as the judges. Therefore, Council 6 to be guided.
Your lead counsel said, yes, because of our behavior, these names were attributed to her. The question is, do you agree with that or do you disagree with that?
Yes, my lord, I do agree with those statements.
You do agree with that. So there was an innuendo referred to her.
Well, my lord, much obliged. So when you talk of an innuendo, it was not referred to her in this particular case. We did not refer to her. My client rather
Then
did
who
not
else
refer.
did the words refer to, and who would be acting like that so that we attribute the words to, if not her?
Much obliged, my lord. As it is stated in the IBA, or the Independent Broadcasting Authority, it gives in to the independent medias to publish information. Therefore, I would
Information
go
that is defamatory.
much obliged, my lady. The information was not defamatory because all the elements were not qualified in this particular case. The plaintiff, much obliged, my lord.
Say the statement is defamatory, published, and referred to the plaintiff. So you agree that the word commando in this instance had referred to the plaintiff because of that behavior, right?
No.
So she was misguided.
We seek to be guided by the judge.
No, you tell me. It's your persuasion. You came here with full confidence that you are very sure of what you're saying. Did it refer to her?
Well, my lord, I still go back to my statement to see it did not refer to her.
It did not refer to her. Commando, Miss G, and all of that did not refer to her. So you are conflicting what you say. Nevertheless, go ahead.
Much obliged.
Does a media statement just make a statement out of nowhere? A journalist responsible wake up and say, all commandos got into a fight and an argument. They are from lawmakers to lawbreakers. Considering Article 20, freedom of expression, what are the limitations of the freedom of expression? We just list those that qualify in this case. What would be the limitation to freedom of expression?
Much obliged, my lord. So the limits in the freedom of expression is that another person's rights should not be infringed in the process.
Do you think Ms. Patel felt her rights were infringed?
Much obliged, my lord. Well, this was, I can call it to say it was just a fair comment. It did not shoot at the target.
Is it the truth? It's a fair comment.
Much obliged, my lord. Like I earlier alluded to say, we have many commanders. We have
the truth? Is it the truth that she entered into a scaffold fight? Do you agree that she did?
No, my lord.
She didn't enter into a fight. So the media journalist was lying. Right?
Much obliged, my lord, but she was not lying. She was just moving on the facts that were given to her by the person she consulted.
Because you as counsel, you are representing. You are disagreeing with them. They are saying that no, it didn't actually happen. So they are publishing based on the facts that you have that there was a fight. You, on the other hand, are saying there was no fight. You are leaving your client alone. That's for them to do. You have to understand it now.
Much obliged, my lord. Counsel seeks to be guided on that.
No, you tell me what you want to counsel. It's you, your client. I should tell you what I should give your client. I'm now the counsel for your client. What do you want for your client?
Much obliged, my lord. All I seek for and pray for my client is that there should be a reduction on the exemplary damages.
That's all. Sure. The statement was defamatory, but let's just reduce.
So you're agreeing to this. You just need a reduction.
No.
Was it defamatory?
It wasn't defamatory.
It wasn't defamatory. Is the information true or false?
The information, with the facts that we have at hand, the information was true.
So the fight actually happened. Based on your reading of the facts, they actually did happen.
Much obliged, my lord. What I mean to say by it was true. The information being given by someone who works in that particular office gives in the credibility to my client.
You refuse. You say it's hearsay. That's inadmissible. Are you going against them? Again?
No, my lord.
Did it actually happen?
Much obliged, my lord. Well, just to follow the principle of teamwork, I'll go with the statement to say yes, statement.
Did it happen? Did they fight? Is the question. In spite of teamwork, did they fight?
Much obliged, my lord. Well, with reference to information that was given to my client by the assistant, I therefore go to say there was a fight.
There was a fight. Your reading of the facts proves that there was a fight.
Yes.
Are you sure?
Counsel, I think think we've heard all what it again. Sit your prayer.
Much obliged, my lady and my lord. My prayer, we humbly pray that this honorable court grants this appeal.
A reduction. Right. A reduction because it was different.
Pray for a reduction.
Council seeks to be corrected.
Don't say guided again. I think you've used it enough.
Fine, you can sit.
Much obliged.
These are parents. Let's have parents.
Much obliged, Your Lordship and Your Lordship. Appearing before you is Mr. S. Nandi, appearing for the respondent.
Say your full name.
Sanford Nandi. Much obliged. Much obliged.
Much obliged, my lady, my lord. Appearing before the court is Isaac Chama. Much obliged.
Much obliged, Your Lordship. Before council proceeds, council wishes to make few amendments orally. Phase 1 to Order 8 of the Court of Appeal, which stipulates the practice and procedure.
You are aware that amendments are very so those may affect your remarks.
Much obliged.
Okay.
On our submission where it's written applicant, kindly erase it, should read respondent. Only wish to make one amendment.
Applicant or applicant?
Applicant. Much obliged.
Continue.
Much obliged, my lord and my lady. Standing before is Sanford Felix Nlambi again, strongly saying the first ground, which is the High Court, was correct.
A lot of data. Loaded here.
Much
I will
obliged.
be amused.
The High Court was correct in rejecting the defense of fair comment. That is my first ground, meaning there was no misapplication of the law. The second ground being the High Court was correct in rejecting justification as a defense from the appellant. Council seeks leave to proceed into the substantive arguments. Much obliged, Your Lady, my lord. The first argument, which is the fair comment, does not apply in this matter in council, owing to the fact that the fair comment applies only if something expressed is an opinion but not a factual assertion. That's one of the standards of fair comment. The other one is based on true facts. That's the second element. The third element of fair comment is made without malice. But this is pursuant to Section 7 of the Information Act, Cap 68 of the Laws of Zambia. When I talk of malice, the publication, which is libel, which is permanent.
What is legal?
Libel as defamation is a defamatory statement that is made of, that is permanent, which is published either in a newspaper or televised, and it is actually press. Injury should not be brought.
What? It is a
Libel is permanent.
Come word after another. Because I want to understand what you're saying.
Much obliged, Your Lordship. Libel is a permanent defamatory statement which is published either on newspaper or televised. Owing to the matter in council, the Times 370 television published televised to say the law enforcer is now a lawbreaker, meaning the publishment did not fall under fair comment because those were factual assertions and not an opinion.
So, in a fair comment, you not only have opinion, but you have fact, isn't it? matter of without malice?
Yes, that is an element.
When we consider this, do you think she was liked? Was she liked?
Much obliged, she wasn't liked.
She wasn't liked.
That is why she was called Mama G, Silencer, and Commando.
So the statement from the accountant, we can also base it on the premise that he would most likely have said that because he didn't like her. Right.
I dispute that, my lord.
Is the accountant also a workmate?
Yes, the accountant was a workmate.
Did the workmates like her?
The workmates, if we conduct a presumption, let's say
don't presume. Did the workmates like her?
they did.
They did like her. So you've changed your statement now. They didn't, now they do.
Council 6 to be corrected.
So what's your assertion?
My assertion is the workmates did not like her.
They did not like her.
Yes.
So let's just take it as also a yes that the accountant also didn't like her. And you go in court, you believe that the journalist made most of his assertion on the premise of what the accountant said, right?
Yes.
So when he's saying that, there is a very high probability that the statement was made out of malice.
Much obliged, Your Lordship. But I tend to dispute that fact, Your Lord.
Why are you disputing it when you agree to it yourself? You led me to this.
The appellant's primary source was, of course, the accountant, which is allegedly saying he did not, he or she, not knowing the gender in the facts in castle, did not, or he or she did not like
Which you have said.
the commission. Yes, but again, we need to respect the fact that for fair comment to suffice and justification to suffice, there should be an eyewitness and someone not corroborated to them, right? So let's take for instance, of course, the accountant did not like the commissioner, and owing to the fact that she was allegedly, and it was contended that she entered into a fight with Jane Banda, the superintendent. Owing to the fact that he or she, the accountant, did not like the commissioner, he or she would say yes, they were in the fight for her being transferred. Yes.
So that means most likely
Then?
most likely there isn't any malice.
You know, the malice rise on the publication, not the accountant. Owing to the fact that
publication is owed to the accountant. Would there have been a publication of the accountant? Yes or no? Just that.
No, my lord.
There would have been no publication.
Yes.
So we can assume, according to you, that the accountant was in good terms. So that means if we must consider fair comment, it doesn't exist. There is no defamation.
No, defamation is not right.
You just said it isn't.
No, I'm saying it's there.
It's there.
Yes.
That there is defamation. In spite of the fair comment.
Yes.
If a person doesn't like you and they make a statement, and that statement has very high probability of having malice in it because I don't like you, is that still fair comment?
That's not fair comment.
It's not fair comment.
Yes.
So then there is no defamation.
Defamation is there, but fair comment as a defense is not there.
It's not fair.
Yes, my lord.
That's what you're saying. Back to the question. Did they like her?
Who? The commissioner. Much obliged, they did not like her. Yes.
Is the statement of the accountant true or false?
The accountant saying
Based on the facts, is it true? Is it false?
it's false.
It's false.
Yes. Council 6 to proceed. Much obliged, Your Lordship. The appellant's report did not merely express as an opinion but asserted as facts that the respondent was involved in a punch-up with their co-worker at that company. The report did not present the event as speculation but analysis of actual occurrence. And anything that is not of an opinion but factual is not under fair comment. So meaning fair comment did not suffice. Owing to the fact that the publishment was done of the actual occurrence but not public opinion.
Alright, so the fact did actually happen. Actual occurrence means it did actually happen, right?
Yes.
And the accountant gives his view. Oh yes, Yes, they are arguing. They got into a fight. And the statement is published on that. There is an actual occurrence, but because this is a public figure, it is defamatory.
Pardon?
That's what you're saying.
Council 6.
The occurrence occurred.
Yes.
Actual occurrence. So the publishing of the statement was based on the actual occurrence, is it? Yes?
According to the publisher, yes.
According to the publisher,
Yes.
it's based on actual occurrence.
Yes.
Then why is there defamation if it's an actual occurrence? Meaning it actually did happen, meaning it's actually true. And it is all to the public for them to know what's going on, isn't it? So there is no defamation. Wasn't it a fair statement to say because of what I saw, which is what you're saying is an actual occurrence? They just gave their fair comment. Fact and opinion. It did happen, is what you're saying. So if he makes a comment on that, you have agreed that it's fair. Then there is no defamation.
No, the comment, my lord, wasn't fair.
The comment wasn't fair.
Yes.
Just to be fair.
I said my
How
lord.
is it not fair, but the fact is true?
When I write it back to the elements, there's an element which says for fair comment to suffice. The element of opinion should suffice, not factual assertion.
So fair comment has no business whatsoever with fact, but only opinion.
Opinion, because that's a public
Are you
interest
sure
issue.
about that?
Yes, my lord.
The person can give their opinions on things that becomes fact.
This can be seen in a persuasive causa, the case of L. Unton and Co. Mrs. Jones.
Says.
Let me read from the script. The court emphasized that even unintended defamation is actionable if it conveys false information that damages
Can you be
reputation.
slow here? Very fast.
Much obliged. The court emphasized that even unintended defamation is actionable if it conveys false information that damages reputation.
False information.
Yes.
You have said it's true. It's an actual fact, isn't it? It actually happened. Then how is it still defamation? It's defamation if it's false, and you say it's an actual occurrence. Yes?
I also seek to be corrected.
You seek to be corrected. The
Yes,
correction
but
is
for
that you
my-
say that it's actual fact.
I depart from my earlier.
Which one exactly? Everything or just
No,
this?
the actual fact. The statement that was done by the accountant was false, owing to the fact that the journalist did not paid attention to the accountant, but did not have an eyewitness.
Did you conduct a reasonable inquiry?
No, not with me.
When you couldn't, is the accountant someone you'd say is personally affiliated with the commission?
Not really.
They know that this is how she is.
Of course, my lord.
They know, right? So most likely they would know what she would do and what she wouldn't do, right?
Yes, my lord.
So what if it actually happened?
But when we go back in the facts in Castle, it says Mrs. Mercy Patel was in the office holding a meeting when James Banda, I seek to be corrected, made a sound, which was obviously noted by the publisher to say it was a puncher. That's what the facts in Castle tell us. Castle seeks to proceed. Additionally,
Prayer, counsel.
much obliged to your intervention. Our humble prayer in this honorable court is that this honorable court dismisses this appeal and upholds the High Court's decision. Much obliged.
Much obliged, my lady, my lord. If it pleases this court, I would like to say the news report clearly identified, defamed, and caused harm to the reputation.
Because I wasn't convinced by the lead counsel with his arguments. So kindly fill up all his gaps.
Much obliged, my lady. Council seeks permission to have the time clear overview of the specific gaps that are intended to be
Just
filled.
everything, your argument.
My argument
Yes. Both of them.
for the argument.
Compensate.
Compensate. Make up for all his gaps.
Much obliged. Council seeks leave to make amendments to his arguments because I was the person who was supplemented because this team had fell short of the representative.
You are the evidence. You have no no business with the respondent side of this question. I had supposed both parties, the person either respondent or appealant, would have to be acquainted with both facts. Are you?
Much obliged, not the specific fact that was alluded by counsel.
Okay. Okay then. Give us what you have for us.
Much obliged, my lady. My argument is that the defamatory statement was made towards the respondent, Ms. Patel, and it did defame, clearly identify, and tarnish the reputation of the respondent.
Can you prove to us how it is?
Much obliged. Counsel 6.
Can you prove to us? You have both them. You have the evidentiary burden, isn't it? The order. You have of reducing evidence to prove that no, this actually prove to us just how
The reputation. Much obliged. The statement that was made in the news report stating that, or specifically alluding from law enforcer to lawbreaker, is a defamatory statement in the sense of reasonable members of society, even reasonable members of an organization in line with the respondent's work, wouldn't want to adopt someone who's regarded as a lawbreaker in society. Hence, it tarnished the reputation of the respondent in that manner.
on that very fact, would any reasonable person out there who comes and he or she sees the news and sees Commander added again in a punch, would that person immediately say there's a connotation to Nancy Patel?
Much obliged, yes, they would.
They would, out of the blues, just think about it. Or it's that one.
Much obliged. As reasonable members of society, it also consists of people that might be acquainted with Miss Patel.
Defamation is an application generally, right? Members of society generally. We're not entirely specific, is it?
Yes,
So when we hold it in a general sense, can you say any person would know exactly what this means when the statement that is defamatory, allegedly, says if you know what it means? Would any reasonable person know what it means?
yes, my lord.
They would know.
Yes, my lord.
Then why did it say if you know what it means? If anybody would just know. They're stupid.
Counsel seeks a repetition of the question.
Why would a person say if you know what it means? Right? There's a common statement, if you don't get it, forget about it. Would a person get it in the first instance that it refers to Nancy Patel, generally, according to you?
Much obliged, my lord. It would, and if it doesn't, my lord, they would seek clarity, which they will find pointing towards Miss Patel, which still leads to the fact that she can be identified. Much obliged, my lord. Counsel seeks permission to present cases that will merely be persuasive to this court. Much obliged, my lady, my lord. According to the case of Cassidy versus...
Explain in what regard they are persuasive. Justify the fact that it's persuasive isn't enough. Justify its persuasiveness. Just don't say it's persuasive. How does it help? Why is it here? It's just persuasive.
Much obliged. The case of Cassidy versus the Daily Mail, where the facts didn't specifically allude to the Miss X that was taken within the pictures of the husband of Miss Cassidy, but a reasonable member of society was able to figure out, or would be able to figure out, to say there is a connection between those pictures and Miss Cassidy. Furthermore, in the case of Houghton and Co. versus Jones, it was alluded to say, even if the defendant did not intend to defame the claimant, but if a reasonable member or reasonable members of society are able to conclude that the defamation or defamatory statement referred to the respondent, then that person would be liable for defamation.
I have two cases. Most likely you quoted it because it has very persuasive help, isn't it? Cassidy and the wife. Those are people who are public figures, isn't it?
Yes,
At least televised them, right?
yes, my lord.
Can we assume that the commissioner was also televised much?
Yes, my lord.
People knew publicly that these two were married, right?
Yes, my lord.
Did the people in this case know that she was called Commander G? Commander and Mama G and all that? Did everyone know around?
Like earlier alluded, like the substantial number of people.
Did they know? Did everyone know around?
Yes, my lord.
They knew that she's called.
Yes.
But then why do the facts say it was only the organization? And because of, would you justify them calling her commander? Would you justify? You say it's fine because of the character. Would you say they were okay to call her that? Nicknames? The way we nickname lecturers based on their demeanor? Would you say it's also okay to call her commander?
No, my lord.
It's not.
It's not.
It's bad.
It's bad. Yes, my lord.
Somehow everyone knew that.
Yes, my lord.
If you call a person commander, commando. Don't we call friends commando? Is that bad?
Much obliged, my lord. It is bad because of the meaning, or rather the initiation that the name Commando or Mama G carried towards the respondent.
Would a stranger know that she was called Mama G because she had such very uninviting character? Would they know?
Much obliged, my lord. Yes, they would.
They would. That, oh, she's called Mama G because she has bad character. Just like Cassidy was accused of wanting to marry someone who was already the wife, alleging that she was unfaithful.
Yes, my lord.
Those two facts, those two cases, just concept. According to you.
Yes, my lord.
Proceed.
Furthermore, to speak from the case of Piri, this is the Zambia Daily Mail, which was presided by the Supreme Court of Zambia. Even an indirect reference of the plaintiff can stand as proper identification for defamation to stand. In this case, it might sound as indirect, but it is even alluded in the facts of the case that people understood, and even the plaintiff or even the respondent confirmed to say people do refer to her in that way because of the hate that they might carry or they might hold towards her having that position.
And so, in my class, there's a person called Dito. Dito's father is not alive. Do you know that?
No.
I have defamed him. His father is not alive. Do you know Dito?
No, my lord.
Then how do you expect any person like you to know that Mama G refers to Nancy Peter? If you can't know, how do you expect the people in here to know this
Proper application of Dito has not taken place for people to even seek
I've told you,
interest.
there's everyone here. Is everybody here a third party? Yes?
Yes.
Yes, they are. And I have said it. It's not true. You can sue me for it because you have heard it. Do you know Dito?
Much obliged, my lord. If someone here is acquainted with Dito, then
Do you know Dito?
no, my lord.
You don't know Dito. Then how do you expect someone who is out there watching it on television, not acquainted, to know that oh, it's Dito?
Much obliged, my lord.
Never been to the offices. Just like you have never been to my class. How do you expect them to know?
Much obliged, my lord. Miss Nancy Patel, as earlier alluded, was a public figure. So a case such as that would definitely be echoed around most places like that. So people
everyone knew that she was called Mama G, silencer, right in the news, in the public domain. They knew, is what you're saying. Right?
Yes, my lord. That being said,
Sometimes I'll say a prayer.
thank you. I'm much obliged, my lady, my lord. Our prayer is that this court upholds the judgment of the lower court and dismisses the arguments of the appellants. Much obliged, my lord.
Why did none of you talk about damages? You're saying it's excessive, so you agree that yes, there was defamation and the damages that were given are excessive. They are appealing that. You have no business with that whatsoever. So we'll take it, you have conceded. Yes, they were excessive and we'll do nothing about it. We're fine with that. Just sit down, isn't it? Agree to disagree.
Disagree, my lord.
You agree to disagree.
Much obliged, my lady and my lords. Council 6, my lord, to repeat the question.
You heard what the appealant said. The damages are excessive.
Obliged, my lord.
Yes, and you have not touched that. That means you have not pleaded. You are not appealing. It does not matter to you. The damages were excessive. It is fine. Praying that it should be sustained, right? And it is now to our discretion to consider whether or not they were excessive, because you don't have a problem with them, right?
Much obliged, my lord and my lady. Owing to the fact that Mrs. Patel repetition was tarnished due to the publication made by the journalist.
And you haven't proved just how it was tarnished, have you? Did she suffer any economic damage, loss?
She did.
She did?
Suffer losses. That's why.
Oh, what exactly is the economic loss you suffered?
Not really economic loss, my lord. But yes, emotional damage.
Emotional?
Yes, and
defamation is not based on my own personal perception. It's general. So let's vouch out what I think personally. My emotions just don't matter here. The question is it defamatory? So other than emotional, there is no other ground on which you can say that tragedy or loss suffices. Yes?
Much obliged. There are losses and damages that
What losses exactly?
owing to the fact that after a punch-up incident was published, she was transferred.
Did she lose her status?
Not really.
She didn't lose her status.
Yes.
Did she lose the amount she was getting?
Not really.
Then most likely she's only entitled to nominal damages because you're just given something in return. And there is no difference, right? You can only say there's a breach of my right here and I deserve this, right? Why should we make it aggravated? Why should we make it exemplary when I have suffered no economic loss?
Much obliged, my lord. Why these damages were made aggravated is that they cause distress. They cause
distress.
Yes, and emotional distress.
Which we have ruled out because it is not based on personal perception, public perception, whether it is defamatory generally.
Much obliged. Due to the fact that when her name was published on
not a name,
yes,
an innuendo, not a name.
An innuendo. Thank you for the correction, my lord. On the fact that an innuendo was published, she suffered emotional distress. Even the crowd would know.
Ruled out emotional distress. Remove that. Prove something else. What other loss did she suffer?
Also seeks to concede.
You concede?
You concede that she didn't suffer any loss.
She did, my lord and my lady.
Are you able to prove what loss that is apart from emotional distress that you keep mentioning?
Owing to the facts in castle, when we critically scrutinize and analyze the facts, we only tend to realize that there was emotional damage.
Your scrutiny and critical analysis proves there is no damage whatsoever except as to how she perceived it and it was hurting. That's all. Yes. Based on your critical analysis, because you have critically thought. There is no point beyond which you can think right now. It's critical. It's very critical. If I'm to think any further, I'll die. Yes? Then what else about your emotion?
She suffered damages because she was transferred. So, owing to the fact that she had
her pay changed?
Her pay?
Salary.
Well, what damage is this you suffered?
That was alluded to the facts in castle.
Then what damage is
it was
this
just
you
stated,
suffered?
much obliged, my lord. Allow me to answer my lady's question and I'll come to this. Owing to the fact that she was changed, but she was restored in the same position. The facts in castle do not state if her salary was tempered.
So she never suffered any economic damage.
According to the facts.
So there is no damage to suffer.
She suffered nothing. There's nothing she suffered.
And we can safely say she doesn't even deserve it.
Doesn't deserve. And I think we can.
You're right. It's excessive and more than that, you didn't serve anything. You give a nominal damages. It isn't true.
I dispute my lord.
You disputed without proof. Yes?
Counsel seeks to consult.
Consult.
Co-counsel.
Counsel is still consulting.
Much obliged, my lord and my lady. Just as the appellants presumed there were no damages suffered, and they are now bringing up a ground of saying the damages, the exemplary damages that were, or punitive damages that were granted to her were excessive. I also presume damages were there, and I
Presume. You don't work with presumptions.
we, my lord, much obliged.
So no damages are suffered. I guess we can.
Thank you,
Much
Counsel.
obliged.
Thank you. Come to the end of our court session. Alright.
So I'm getting a juice.
Much obliged. It's a start.
There's a medium kind of.
Next.
What was the